with the court.
Sir, where did you mail? Well, if you can both please raise your right hands to be sworn in. Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
I affirm.
Yes.
Okay. So, sir, where did you mail your request to on April 26th?
I mailed it to the Lamarck office.
Okay, so you did not file it with the court. Mr. Division, are you able to read what it was? I just want to make sure it was a de novo and not a new trial.
Yes.
Judge, I can share the screen if you would like.
I asked you to read it.
Okay. So the title, it's non-standard. The title he wrote request for de novo hearing. Then he's got his name, and he's got an address, and underneath that he's attempted to put a style, and then he titled it nunc pro tunc, and then underneath that he's got request for de novo. Then he's got another title saying notice to the court, requesting de novo hearing concerning the denial of my affidavit of fact of dismissal of lack of jurisdiction. I am requesting de novo hearing on the following grounds. And he cited several cases. Which is not relevant. And there's a page 2. And he's talking about the post box rule, which is also not relevant. And then he signed it on page 3, and he's got a jurat.
Objection.
What's your legal objection?
I believe that all everything here is relevant.
I'm going to sustain your objection. However, I don't know if it's denying, but I'm going to find that your de novo request, I don't need to wait for that because it was not filed with the court, and it was not filed timely, even if I considered the AG's office the court, which I do not.
Can you repeat that? I didn't
You
hear
did not file it with the court, and you did not timely file it, even if you had filed it with the court. So we're moving forward today. Mr. Dehamajian, you may call your first witness.
Thank you, Judge.
Well, hold on, Your Honor. I have a question. Like, you saying that it wasn't in a timely manner, but it was on the 26th, and notice to agent is notice to principal. Notice to principal is notice to agent.
Today's courtroom clash is one for the Sovereign Citizen Hall of Fame. We've got a self-asterisk who believes that using his government name somehow traps him in a Liga asterisk contract with the state. He's in Texas family court, accused of owing asterisk over $10,000 in back child support. But in true sovereign fashion, he's convinced that if he just says the magic words, "I do not consent," he'll walk away debt-free. This hearing spirals into a masterclass of misunderstanding as he invokes Latin phrases, jurisdictional challenges, and sovereign logic straight off a Reddit forum. The judge, calm and methodical, tries to corral the chaos, while our Moorish friend insists that mailing a letter to the wrong office somehow nullifies reality. Stick around, because not only does he try to redefine the law mid-hearing, he also delivers one of the most unintentionally hilarious explanations of notice ever uttered in court.
Well, it's not even filed. I'm finding it's not filed with the court, and it is not timely. You may proceed, Mr. Dehamajian.
Thank you, Judge. Judge, at this time, the state requests that you take judicial notice of our petition filed on December 6, 2024.
I take judicial notice of the pleading, including the acknowledgement of paternity that was signed by both parties with their all caps names.
Your Honor, I call Miss Tatiana Young-Fleeton. I don't know if she's been sworn in yet, Your Honor.
Don't believe she has. Can you state your full name for the record, please?
Tatiana Young-Fleeton.
And can you please raise your right hand to be sworn in? Do you solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. You can lower your hand. Proceed.
Thank you, Judge. Ms. Fleeton, who do you work for, ma'am?
The Office of the Attorney General.
Ma'am, what did you calculate in this case?
Retroactive child support.
And what were your findings there?
For the year 2021, minimum wage, gross $1256.67, net $1159.87 for 12 months at a total of $232 a month based on 20% for a total of $2,784. Excuse me. For 2022, minimum wage $1256.67, net $1159.87 at 12 months at a total of $232 based on 20% for a total of $2,784. For 2023, gross minimum wage $1256.67, net $1159.87 for 9 months at a total of $232 based on 20% for a total of $2,088. Also for 2023, for 3 months, gross $2,119.80, net $1,870.66. For 3 months at $374 based on 20% for a total of $1,122. For 2024, gross $4,092, net $3,457.80 for 3 months at $600.
Right out of the gate, the judge is laying the legal groundwork. She's citing the Texas Family Code, the remote proceeding, and checking that everyone consents to the format. You know, standard stuff. But notice how the defendant immediately takes issue with his name. That's a telltale sovereign citizen move. They believe that using their all-caps name binds them into a secret government contract. To them, Sidney Miller Bay is a sovereign man, while Sidney Omerville Marth is a asterisk corporate entity. Here's the problem. The court deals with legal reality, not metaphysical fan fiction. And this judge, she's about to remind him exactly where reality starts and ends.
$22 based on 20% for a total of $2,076. For 2024, minimum wage, gross $1256.67, net $1159.87 at 9 months at $232 based on 20% for a total of $2,088. And for 2025, gross $1256.67 minimum wage, net $1159.87 at 4 months at $232 based on 20% for a total of $928. The subtotal $13,870.
The classic opening move I challenge jurisdiction. Every sovereign citizen believes that if they say this phrase, the court suddenly loses power over them, as if it's a video game cheat code. UT watched the judge's response. Calm, firm, and utterly unimpressed. She denies the challenge and moves forward. In actual law, once you appear in court and engage, even on Zoom, you've already recognized the court's authority. So the jurisdiction challenge collapses faster than his logic. That's hilarious here, is that he tries to appeal a denial that hasn't even been ruled on yet. It's like calling 911 to complain that your imaginary lawsuit lost.
Fleeton's testimony.
Don't see the case is even open for today. Anyone have any objection to me entering the exhibit? What was it, State's Exhibit?
1, Your Honor.
State's Exhibit 1?
Yes.
Ms. Blake, do you have any objection to State's Exhibit 1?
No, ma'am.
And Mr. Millar, do you have any objection to State's Exhibit 1 being admitted into evidence?
I do object.
What is your legal objection?
My objection is that I don't wish to contract. I don't have a reason to contract. I do enough already for Sonora and my son.
Okay. I'm going to overrule that objection and admit this into evidence. And do know, sir, you'll get a chance to explain why you don't believe back child support is appropriate. State's Exhibit 1 is admitted, and you may continue, Mr. Dehmasian.
Judge, I pass the witness, Ms. Fleeton.
Okay. You may call your next. Oh, actually, Mr. Millard, do you have any questions for Ms. Young-Fleeton?
I only object to this proceeding because I move to dismiss.
Here, our hero claims he's filed for a novo hearing. That's Latin for starting over from scratch. It's a legitimate legal process, but only a ruling is made. The catch? He hasn't even reached that stage. Judge checks the court's system, and surprise, there's nothing filed. Why? Because he mailed it to office in sovereign circles. There's this magical belief that if you send a document asterisk, the entire government instantly knows about it. Unfortunately, legal filings don't work like Hogwarts letters. They need to go through actual clerks, not postal.
Sydney Millard Bay.
Mr. Millard, what do you do for a living, sir?
I have a question. I'd like to know the proper names for yourself, the judge, and the other officer that was here.
Judge, objection, non-responsive.
I believe that there's a conflict of interest here because at least two of you work for the state.
Okay, I'm going to overrule the objection. My name is Judge Jennifer Baker. Mr. Gary DeHamajan, his name is written right there on the screen. Miss Tosiana Young-Fleeton, her name is on the screen as well. So you may proceed, Mr.
And who are they employed by?
Sir, it says they work for the Office of the Attorney General. You may proceed, Mr. DeHamajan.
Sir,
So everyone works for the Office of the Attorney General?
I don't. You may proceed, Mr. DeHamajan.
Mr. Millard, what do you do for a living?
So you work for the state?
Objection, non-responsive.
Sustained. Sir, please answer the questions.
I don't work.
Are you retired?
I don't understand. I don't understand where we're going here. I already said what I need to say in this matter, but you guys keep pushing.
Here's where the logic completely leaves orbit. He argues that because he mailed something to one government office, every government employee is now automatically informed. He cites the sovereign. Notice to agent is notice to principal. Notice to principal is notice to agent. This pseudo-legal mantra sounds official, but it's meaningless in actual law. Court's not wordplay. The judge even gives him multiple chances to clarify, but he doubles down, as if reciting legal memes will save him. T's like emailing Starbucks corporate and expecting your local barista to know your frappuccino.
Forward. So I'm telling you that I don't want a contract, and you're steady trying to draw me into your jurisdiction, and that's not what I want.
Sir, do you own an 18-wheeler?
I don't understand.
Do you drive a truck for a living, sir?
I don't understand. I don't understand.
Are you refusing to answer my questions, Mr. Millard?
I move the court to dismiss.
I'm denying that request. You may proceed, Mr. DeHamajan.
Mr. Millard, do you live in a home or an apartment?
I live within myself.
Do you pay rent?
I live within myself.
Do you own a car, sir?
I move the court to dismiss.
I'm denying that
Objection.
request. Sir, please answer the question so I can make an appropriate ruling in your case. This is not a contract. International Shoe says I have jurisdiction of you. You were served in Texas. This child lives in Galveston County. We are proceeding with the Attorney General's petition.
I don't understand.
Do you pay rent, sir?
I don't understand.
Do you have a car?
I don't understand.
Judge, the witness is refusing to answer questions.
He's saying he doesn't understand. He might not understand. just ask your questions to the best of your ability, and I'll make my ruling to the best of my ability.
Okay.
You can impeach him if you have impeachment evidence.
Mr. Millard, do you own a phone?
I don't understand.
What are you using for Zoom, sir? What device are you using?
This is a tablet.
Okay, so you own a tablet. Do you know what a phone is? Do you know what a telephone is? Maybe you need.
This is the legal equivalent of watching a train crash in slow motion. The judge patiently explains that his filing was not only the wrong place, ***, but if she were generous enough to consider the AG's office the court, which it isn't, the filing would still fail. Yet he asks her to repeat herself, as though hearing it twice might somehow change the outcome. This is the sovereign. Here comes the meltdown moment. He argues that notice to the agent is notice to the principal. Again, but now with conviction, as if sheer repetition might summon legal magic. The YouTuber nails the tone perfectly. The man sounds like he's been huffing